Picture this. Yesterday, letting someone go who had less than 2 years under their belt, it was a pretty straightforward process, right? You knew the risks, you knew the financial caps. But tomorrow, well, that safe 2-year window slams shut at just 6 months. And that reliable compensation cap, it completely vanishes. The financial and operational stakes are literally about to skyrocket.
Welcome back to The Explainer, everyone. I'm absolutely thrilled to jump into this with you today because we are doing a complete top-to-bottom masterclass on what is honestly one of the most profound legal shifts we've seen in recent employment history. We're talking about the Employment Rights Act 2025, specifically the Commencement Number 4 and Transitional and Saving Provisions Regulations 2026. If you're NHR dealing with corporate risk, or hey, if you're an employee wanting to know exactly where you stand, grab a coffee and a notepad. We're going to cut straight through the legal jargon and get right to the facts.
So, here's our masterclass syllabus for today. First, we'll look at the unfair dismissal revolution. Then, we'll break down the 6 months and no cap rule. Third, the implementation timeline. Fourth, we'll get into the transitional provisions. And finally, number 5, how to start preparing for 2027.
Okay, let's dive into this. Part 1, the unfair dismissal revolution. You know, for decades, that 2-year rule for unfair dismissal has just been a rock-solid, predictable cornerstone of UK employment relations. Employers, employees, everyone knew the framework. But Section 25 of the new Act completely tears up that established rulebook.
Moving to Part 2, 6 months and no cap. The 2025 Act doesn't just bolt on some new laws. It goes right to the bedrock of the existing Employment Rights Act 1996, fundamentally transforming both the qualifying periods and the financial liabilities.
The core change here is remarkably direct. Let me read you the exact text from the Employment Rights Act 2025, Chapter 36, Section 25, Subsection 2. It explicitly states, in Section 108, in Subsection 1, for 2 years, substitute 6 months. I mean, it's just a few words swapped out in the legal code, but the real-world operational impact, it's massive. Employees are now going to gain statutory protection against unfair dismissal a full 18 months earlier than they did under the old rules. The entire landscape for probationary periods is forever changed.
But listen, the shortened time frame, that is really only half the story. Notice the legislative repeals here. Section 25, subsection 3 entirely omits Section 124 of the 1996 Act. Now, for those who might not be intimately familiar with the 96 Act, Section 124 was the absolute critical provision that put a statutory limit or a hard cap on compensatory awards for unfair dismissal. By omitting it, those statutory limits on compensation are entirely repealed. Following right behind that, Schedule 3 brings in minor and consequential amendments to basically clean up the rest of the Act so it reflects this new uncapped reality. So you're pairing a much shorter qualifying time with totally uncapped financial exposure.
Which brings us to Part 3, the implementation timeline. With stakes this high, you're probably wondering, okay, when does this actually happen? To understand the rollout, we have to look closely at the Commencement Number 4 regulations, which dictate exactly when these massive legal shifts become enforceable.
So, the Act itself received royal assent back in December 2025, but it doesn't all switch on overnight. On July 1, 2026, preparatory powers unlock under Section 2555 and Schedule 3, Paragraph 5. Basically, this gives the government the regulatory authority to prep the legal system for the change. But the main event, the date you absolutely need circled in bright red on your calendar, is January 1, 2027. That is the full commencement date of Section 25. That's when the uncapped 6-month rules officially go live.
Part 4, the transitional provisions. Now, what's really interesting about this slide is the gray area it addresses. What happens if a dismissal process begins in late 2026, but the employee actually leaves the company in early 2027? Which rules apply? To answer this, we need to deep dive into Regulation 4 of the Commencement Number 4 regulations.
To navigate these transitional rules, we first have to understand one absolute linchpin legal concept, the effective date of termination, frequently referred to as the EDT. Under Part 10 of the Employment Rights Act 1996, the EDT is the exact date an employee's termination legally takes effect. Listen, it's not necessarily the day you hold a disciplinary meeting, and it's not necessarily the day you hand them their notice letter. It is the very day their employment contract legally ceases to exist.
If you are an employer or an employee navigating a dismissal right around the new year, this binary outcome is literally everything. If the effective date of termination falls before January 1, 2027, the old rules apply: 2 years of qualifying service and capped compensation. However, If that EDT hits on or after January 1st, 2027, the new rules instantly kick in. 6 months qualifying period and uncapped compensation. It is a hard, completely inflexible dividing line.
Let's consolidate these mechanics to ensure we have this locked in. So the crucial point is laid out right here in the Regulation 4 fine print. The date you initiate the dismissal, not the deciding factor. The effective date of termination is the sole trigger. This means pre-2027 dismissals with post-2027 EDTs are fully subject to Section 25. Let me give you an example. Say you give an employee a 2-month notice in November 2026. Because of their notice period, their EDT will fall in January 2027. Because their EDT is in 2027, they fall entirely under the new 6-month uncapped rules, even though the dismissal process started under the old rules. And remember, those preparatory powers activate on July 1, 2026, allowing the state to finalize all the regulatory details before this tidal wave hits in January.
Which brings us to Part 5, preparing for 2027. You know, understanding the mechanics of the law is one thing, but actually applying them, that's another. Why does a January 2027 timeline matter for your operational readiness today? Because overhauling your employment practices, tightening probationary periods, training management, and restructuring performance reviews, that all takes months to implement properly. You absolutely cannot wait until December 2026 to figure this out.
I want to leave you with this final, kind of provocative thought. With the 6-month clock rapidly ticking down and the historical compensation cap completely removed, is your organization truly ready for the 2027 revolution? The legal landscape of unfair dismissal has been fundamentally and permanently altered by Commencement No. 4. Understanding this timeline is your very first step toward readiness. Thank you so much for joining me for this masterclass on the Explainer. Keep learning, keep preparing, and I'll see you next time.